Chelsea, welcome back. Today we're going to really dive into, do people really need a real estate attorney in Florida, and talk about some of the truth and the lies and all the things about title companies versus law firms. So let's start with something that surprises a lot of people. In Florida, you don't actually need an attorney to close on a home, right? So why are we doing a whole podcast episode about that?
I think the reason is pretty simple. Just because Florida doesn't require an attorney for a closing doesn't mean having one isn't still your best option. The reality is that Florida has such a high volume of real estate transaction that the system really isn't set up for attorneys to be the only people legally allowed to handle them. But when you do have the opportunity to have an attorney involved, especially someone who is board certified in real estate law, that's something worth taking advantage of.
Now, um, we may have heard about this in an earlier episode, and definitely don't name any names. But what's the most expensive mistake you've personally seen a buyer or seller make because they didn't have an attorney involved in their closing?
Yeah, I've seen a lot of mistakes in my experience. Most recently, just last week, I had a buyer who purchased $1.5 million home. Later, realized that the neighboring property was zoned for the highest possible density of commercial and residential development. So, in practical terms, that means the quiet single family street that he thought he was buying next to could very well become a bright, busy commercial project in just a few years.
And I've heard some of those terms before when I've been involved in real estate transactions. And you talked about some of the things that you do there. Help us understand the difference or distinction between a title company and a real estate attorney. What a title company does versus what a real estate attorney does. Because from the outside, it often looks like you're kind of doing the same thing.
Yeah, absolutely. It can look very similar from the outside because both an attorney's office and a title company are involved in helping a transaction get from contract to closing. I think the primary difference is the legal understanding, knowledge, and expertise underlying the entire transaction. Now, I don't want to speak for every title company because they're not all the same, but in many cases, the work in title companies is divided into very specific roles. So, one person may be placing orders, another person is scheduling sightings, another generating documents, another, handling the review of reports that come in. Um, what that structure can lack is someone who is looking at the transaction as a whole and fully understands how one maybe seemingly minor detail could have a major legal impact on the transaction or even after the transaction has closed.
Mhm.
So that's where a real estate attorney brings something different to the table. I'm not just helping move the file along. I'm trained to spot risk, understand the legal significance of all of the details, and evaluate how one issue may affect the transaction before closing. In my office, for example, we have 3 meetings every week where I sit down with my team and go through all of our upcoming files with a fine tooth comb. So we're not just making sure that the tasks are getting done and we're checking a box. We're making sure that everything is on track, being done correctly, and we're looking ahead to make sure that nothing unexpected is gonna pop up prior to closing.
Okay. And I've often heard it described that title companies are doing insurance and administration. Um, if that's what they're doing, what gets left out? What is left out in that process?
The legal judgment and the problem solving that real estate transactions often require. The insurance and administration aspect are important. I mean, my office has to do it as well, but they're by nature just very transactional. A lot of it can become a check the box type of work, clear this item, prepare that document, get something signed, move to the next step. But the problem is that real estate deals don't always fall neatly inside of these boxes. And unfortunately, what I have seen happen many times is when those issues do fall outside of the boxes, some of these title companies will just try to sweep it under the rug so that their clients or their referral sources don't know that they don't know how to handle something.
Okay. And when a title company is reviewing a title commitment, what are they looking for? And what are they not looking for that an attorney, a real estate attorney, would catch?
In my experience working with title companies, when they're reviewing the title commitment, all they're looking at is Schedule B1, which is telling them in a very like itemized list fashion what they have to do to get the contract close. Um, that includes satisfying a mortgage, obtaining lien releases, payoff items, getting your deed signed. What they're not looking at is Schedule B2, which is just as important as Schedule B1, especially from a buyer's perspective. So Schedule B2 identifies all of the matters that are going to remain exceptions to the buyer's title insurance policy after closing, meaning issues that the buyer is going to be taking title subject to after closing. Some issues that are pretty common that will show up on Schedule B2 are things like rights of tenants,
Hmm.
mineral rights, easements, rights of access to the property. Those aren't just technical entries on the title commitment. Depending on the property and how the client is intending to use the property, they can have really severe consequences.
Can you give us a real world example where a title issue surfaced and a real estate attorney or you in particular made a difference between the deal closing or falling apart?
Yeah. Yeah. One example that comes up fairly often these days involves ingress and egress easements. So, a lot of the easements that exist today were drafted or added to deeds 20 or more years ago.
Mhm.
While they may have been enough at the time, they're often not sufficient for how properties are being used now.
Mhm.
They may technically grant access, but they don't clearly spell out what the parties can do, who's responsible for maintenance, or very importantly these days, who bears liability if something were to happen in the easement area. So that's where I can make a real difference. I have had situation where an old easement existed. At first glance, it looks like it's not an issue, but especially when you have educated buyers, once you read it carefully, it's obvious that it provides too many unanswered questions for a buyer to feel comfortable closing. And in those cases, the legal work is not just identifying that the easement exists, it's evaluating whether it's actually adequate for the property and the transaction. So there have been numerous transactions over just the past 2 years that I have negotiated new easement agreements to put of record, making sure that both parties are protected and that they understand their rights.
So Chelsea, what is like a missed contract term that you've seen cause real financial harm to a buyer or seller after closing?
Yeah, I've seen a variety of different terms that can cause issues post-closing. Off the top of my head, the one item that comes to mind that I've seen a few times even recently is a buyer waiving their right to have taxes reprorated once the tax bill comes out. So in Florida, the property taxes are taxed in arrears. So for 2026, for example, the tax bill won't even be released until November 1st. If I have a closing transaction that closes today, the buyer should be contractually allowed to come back to the seller in November and say, hey, the tax bill is different than what we estimated at closing. I need you to reprorate this and give me some extra money. Um, I have seen multiple situations over the past couple of months where buyers at the closing table are waiving that right. They don't even realize they're waiving their right to do so. And that could be a difference, depending on how rapidly the taxes are changing between a couple hundred to a couple $1,000s.